Good morning. Happy Saturday. This is an addendum to the video I made yesterday on the Leon Valley summary judgment. And the one thing that I didn't mention there that has been kind of weighing on my mind is that there weren't any state claims made. Now, I don't know if Texas has any state causes of action that could have been applied to the events in Leon Valley. I don't know that. I am not licensed to practice law in Texas. I don't know. But I do know that in California, there are various additional protections that you can use to sue, for example, the police if they violate your constitutional rights. Exactly the same as it would be under a 1983 lawsuit. In fact, you can sue under 42 U.S.C. 1983 in California State Court. And you can additionally sue, for example, with under the Tom Bain Civil Rights Act, that's California Civil Code, Section 52.1, at the same time. And unlike the 42 U.S.C. 1983, which only allows for violations of your rights under the United States Constitution, the Tom Bain Civil Rights Act in California also protects your rights under the California Constitution. So it's the Constitution or laws of the United States, or rights secured by the Constitution or laws of this state. So you have more sources of potential violations by the police in, for example, a Tom Bain's Civil Rights Act lawsuit. In addition, unlike in a 42 U.S.C. 1983 lawsuit, you are eligible for treble damages, treble the actual damages. Actual damages include specific damages and general damages. Specific damages are the things you could actually show a receipt for, like I spent, $100,000 on medical bills because of the violence that the cops committed against me. So that's actually a specific damage because you have a specific amount that you could show a receipt for. General damages are your pain and suffering, loss of consortium, things like that. And those are generally speaking, somewhere between 2 and 6 times, generally speaking, what the specific damages are. So if you had $100,000 in specific damages, you can estimate that you'd get somewhere between 200,000 and 600,000 in general damages for it. In addition, you can get punitive damages, which are constitutionally capped somewhere around 8 to 10 times what your actual damages are, the specific and general damages. And you have a minimum of $4,000 in a Tom Bain Civil Rights Act, and you get attorney's fees, which you don't get attorney's fees in a lot of things. You can get attorney's fees in 1983 lawsuits, but you can in other causes of action, at least in California, there are no attorney's fees. So like if you sue someone for battery, you don't get attorney's fees. You're not eligible for attorney's fees. Usually it's only things like contracts or statutes that specifically state you can get attorney's fees on. So the big deal about the Tom Bain Civil Rights Act is that whereas in a 42 U.S.C. 1983 lawsuit, they can give you nominal damages if you don't show enough damages. In a Tom Bain Civil Rights Act, you can get a minimum of $4,000 plus your attorney's fees, but you can get your attorney's fees in the 42 U.S.C. 1983 lawsuit as well. So, I mean, there are just advantages to it, and there's no qualified immunity on a Tom Bain Civil Rights Act lawsuit. So, I mean, there's just I don't know if it helped the plaintiffs in the Leon Valley case to hire an attorney who was an out-of-state attorney. The attorney they hired, I forget his name, but he was out of like Illinois or somewhere up north. It doesn't really matter. Oh, John, you never have the facts. Yeah, because it doesn't matter. He was an out-of-state attorney. That's the part of the fact that matters for this analysis. So he comes down to Texas. He associates with other counsel. Uh, he's appearing pro hac vice. For that, he's only allowed to appear for this one case. He's not actually admitted into the Texas state bar, and he doesn't know Texas state law. I mean, that's like if I went down to Texas, I wouldn't know Texas state law. I don't know Texas state law. I wouldn't really be able to. I wouldn't know what to look for to find what the actual law was, or maybe I would, because I'd sit down and I'd just go through everything, try to figure out what I could allege as a cause of action, because I'm I'm not the pick the best cause of action and run with it kind of an attorney. I'm a pick all of the causes of action that I could plausibly argue, throw them at the wall, and let the judge figure out what doesn't stick. And you could say that's because I'm lazy, but I say that's because I don't want to limit myself to, you know, I don't want to cut any potential avenue of recovery out. There are some attorneys out there who they'll pick like the best cause of action and go with that. And that's also fine. I mean, it narrows down what they have to argue. It narrows down the elements that they have to prove and everything like that. I just, you know, maybe I'm just not experienced enough as an attorney to feel comfortable doing that. So, but anyway, long story short, they hire this out-of-state attorney who only pleads a federal cause of action because, you know, federal law is federal law. It doesn't really matter where you go. A 42 U.S.C. 1983 lawsuit is going to look the same everywhere you go. There might be minor variations based on case law in that particular circuit, but it's going to look pretty much the same. You can walk into Texas, into the Fifth Circuit, and file a 42 U.S.C. 1983 lawsuit that's going to look basically identical to a lawsuit that you would file for 42 U.S.C. 1983 in the 11th Circuit. So, but if you don't know the state, there might be a state cause of action that is better and can actually protect you from things like getting some of your charges, get causes of action dismissed because of qualified immunity. And in reality, the Leon Valley, there's a lot of things in the Leon Valley lawsuit where the court said, yeah, this is actually a violation. You're violating rights, but it's not clearly established. So the cops get to get off on this one. And if you want to avoid that, people always like, oh, you know, the state courts are corrupt. Well, try to bring it in federal court if you really want to do it. You know, federal courts can entertain state causes of action as long as there's a some sort of a federal cause of action in there, or diversity jurisdiction. So they can entertain state causes of action, or like I know for a fact that you can sue someone for 42 U.S.C. 1983 in Texas state courts. You can do a 42 U.S.C. 1983 lawsuit in Texas state court, and you could tack on whatever Texas state law causes of actions exist in Texas state court, and you could run with it from there. So, you know, you've got options, and I just want to make sure that people are aware that I hear all the time, oh, I'm going to sue you in federal court. Like these cops don't get sued in federal court all the time. You know, it's not scary to them. So don't limit yourself. Just keep an open mind. The states also make laws to protect you. The state constitution exists to protect you. State laws exist to protect you. You know, don't limit yourself to federal court and federal causes of action unless that's actually the best route for you to take. Thanks for watching. Have a great day.